My name is Takashi Ono. I'm the chair of the Committee on Corrections, Military and Veterans Affairs. We're here to talk and hear an update to this committee about the early release of inmates during the COVID-19 pandemic. Before I get started, I do have a couple of housekeeping topics to mention. This is a Zoom info briefing for the members who are on the call. This informational briefing is being live streamed on the House YouTube page, and a recording will be made available after we adjourn. Closed captioning is available on YouTube. So to the other members on the call, please speak clearly and try to refrain from talking over each other or speaking at the same time, because that makes it hard to create an accurate transcription. And for the members on this call, we will take questions at the end of the presentations. You can indicate in the chat if you have a question, and I will call you to ask it. On to the bulk of the presentation. Again, we'll be hearing an update about the COVID-19 inmate release. As a result of Act 5, there were weekly reports that have been issued from the judiciary detailing information for all the inmates released pursuant to the Supreme Court orders, including new cases filed against them. The public defender wrote to the Oversight Commission just a few weeks ago on December 29th, 2020, that, quote, the releases during the COVID-19 pandemic did not compromise public safety. That's one of the questions we'll be addressing. Was public safety compromised? We'll also be talking about recidivism statistics and released inmates, impacts to saguaros, correctional center transfers, and whether ultimately the inmate release program reduced COVID-19 in our jails and prisons, which was its stated goal. Okay, we're going to get started. Our first presenters are the Department of Public Safety. I believe it's Director Otani. Are you there?
I am. I'm with my deputy directors, Tommy Johnson and Maria Cope. All right, let me just start by saying that the Department of Public Safety has not tracked recidivism on these early releases, just to get that out of the way. And the term early release is very broad. I've kind of broken it down based on the knowledge that I got recently. We had the order that was issued in March of 2020. Unfortunately, the department was not tracking the releases at that time. We also had judge's discretion releases due to COVID. Those were not tracked also. What we did track was the Supreme Court orders in August of 2020, at which time it showed that we had 420 releases, and the breakdown was from August to September, we had, we had 402 releases. Excuse me, the numbers don't add up here. And October, we had 16. November, we had 12. We had not had a release since November 20th of 2020. The initial month we had, it's supposed to be 430. I'm sorry. The initial month that we had these releases, we had releases from the neighbor islands, but since September 30th, there were no releases on the neighbor islands. The other category that we would like to talk about is the releases of convicted felons and parole violators. So this is the releases that the Hawaii Paroling Authority conducted. So during the same period of time, we had 670 people that were granted release on parole. Of those, 461 were actually released. The remaining 209 are still awaiting verification of residence or an appropriate place for them to reside at. In all, in calendar year 2020, the Department of Public Safety had a total of 8,656 releases. Moving on to impact to Saguaro Community Correctional Center. We anticipated interruptions between Hawaii and Saguaro, and therefore we took the appropriate actions. On August 5th, 2020, public safety transferred 156 long-term sentence felons to Arizona. And in return, we brought back 196 felons that were either granted parole, pending a parole hearing, or were scheduled to complete their maximum term through May 2021. On December 9th, we transferred 79 inmates back from Arizona to Hawaii, and these were for parole purposes or completing maximum terms or further programming in Hawaii. However, the flight that was scheduled to return to Arizona with 151 inmates on board was canceled due to abundance of caution because of suspected COVID infection among the inmate population. We did not send anybody up to Arizona at that time. Questions regarding health and safety protocols for individuals entering and exiting prison systems. All offenders entering the prison systems are thoroughly screened to determine their medical, mental health treatment and medication needs. Inmates can sign up for appointments with facility medical professionals to address their needs. PSD also routinely review cases to ensure the inmates' medical, mental health, and treatment needs are being met, which includes referrals to outside medical specialists as needed. What we did under the current COVID situation is that normally we would screen, and if the person displayed any need for medical, we would refer the person over to the medical unit. In current practice now is that the medical unit is in the intake area doing the medical screening themselves. Offenders exiting the prison system receive community standard care while incarcerated, which includes access to medical facility staff, referrals to medical specialists, prescribed medication and therapy. Treatment services are provided on initial and follow-up medical screening. Inmates are also provided at least 2 weeks of prescribed medication upon their release to help them bridge between the time that they get to see their primary care physician or seek assistance from the Department of Health. I would be open to any questions you may have at the end of this presentation. Thank you.
Thank you, Director. Thank you for the quick arithmetic as well as you went through those numbers. I'm sure we'll have some questions. Members, we'll take them all at the end. Next up, we'll be hearing from the judiciary. I understand there are a number of presenters from the judiciary. First up, well, I'll let someone from the judiciary if they want to start introducing folks, but on my agenda, we have 3 folks starting with First Circuit Judge Matthew Viola. Judiciary folks, can you add to this conversation surrounding the early release of inmates due to the COVID-19 pandemic?
Yes, Chair Ono, if with your permission, if I can start and in short order, turn it over to Dr. Harbinson, I think, for the bulk of our presentation. I did want to say good afternoon again, Chair Ono, Vice Chair Ganadin, members of the committee. I apologize if I couldn't keep track of everybody as they were checking in, but I think I've seen Representative Kobayashi, Representative Kong, Representative Morikawa, Representative Tarnas, and is it Representative Bronco as well? And I'm sorry if, and I don't know if I saw Representative McDermott, but if you're there, good afternoon as well. I am, as Chair Ono indicated, Judge Viola, Matt Viola. I am First Circuit Court Judge. Just by way of background, I'm currently assigned to preside over the treatment courts in the First Circuit. So that's Stroke Court, Mental Health Court, Veterans Treatment Court. I also handle Hope Probation Calendar, and I am also the chair of the board of directors of the Criminal Justice Research Institute that Dr. Harbinson now directs. Also today with me is Dwight Sakai, who is the Deputy Chief Court Administrator in the First Circuit. And of course, Dr. Aaron Harbinson, who recently, and I really want to emphasize the recent part, just came on board as the director of the Criminal Justice Research Institute. So just let me, if I can say a couple of prefatory comments. First of all, we really do appreciate the opportunity to provide the committee with information regarding the impacts of the COVID-19 pandemic, and in particular, in light of the purpose statement in the notice of information, we'd like to provide information regarding the release of inmates due to the COVID-19 pandemic, including recidivism statistics of released inmates. As I mentioned, Dr. Harbinson will be our main presenter. She's going to discuss some of the data that we have so far and discuss any conclusions that can be drawn from that data. She's also going to outline some further questions or research areas that we think might be helpful in helping all of us understand not just the short-term impacts of the releases, but the longer-term impacts as well. And that is not just on public safety, although that, of course, is always one of the paramount concerns, but also, for example, the impact of some of the adjustments to supervision of defendants on probation that were implemented as a result of the pandemic, and the impact of the availability of or the lack of availability of reentry type services such as substance abuse treatment, mental health treatment, and housing that resulted from the pandemic. And then before I turn it over to Dr. Harbinson, I would like to say that we really do appreciate the committee asking these questions. They're important. They're important questions, and they deserve answers, and they deserve answers based on data and objective information. And I can assure you that the judiciary is very much interested in these questions as well, and the answers as well. And also just do want to take this opportunity to thank the legislature for establishing the Criminal Justice Research Institute a couple years ago. As everybody knows, I think, the Institute was established in part to help study the criminal justice system and to answer some of the questions that are being asked by the committee today, to conduct research into questions such as those posed by the committee, and to use data and objective information to help all of us improve the criminal justice system and its outcomes. So with that said, I would like to turn it over to Dr. Harbinson, who has prepared a presentation with some slides to follow along. Dr. Harbinson.
All right, thank you. All right. Can everyone see the presentation okay? Great. All right, so first off, thank you, members of the committee. Really appreciate this opportunity to talk about data and research. As you're aware, that's the goal of the Research Institute, to use data to understand the criminal justice system. So really appreciative of this opportunity today to talk about that and to talk more specifically here about some of the trends around releases that occurred this year. I apologize. Now I have to figure out how to get my, there we go, to get the slides to change. So before I get started, I'll just briefly outline the discussion we have for you, our presentation. I'll just very briefly, Judge Viola already introduced the Criminal Justice Research Institute, but just mention again a couple of its responsibilities because it really ties into some of what we're going to talk about today. Also, the main point of interest most likely in this discussion is talking about some of the preliminary data around people who were released this year under Supreme Court order. And then also from that, I'll talk a little bit about some research opportunities that we've been thinking about at the Research Institute to understand these trends. And the kind of further research questions we have are partly to illustrate just some of the challenges in understanding these trends in terms of what they mean for public safety now and what they might mean in terms of lessons learned for criminal justice practices and policies in the future, and to kind of illustrate some things that we've been thinking about that are important and related to this topic as well. So again, the Criminal Justice Research Institute, and I just want to echo Judge Viola's comments earlier. I'm really excited to be here. As he mentioned, I just joined fairly recently, but it's a really exciting opportunity to see a state think about how to use data to use that information to improve criminal justice policies around public safety and other community outcomes. So really grateful to be here and to be part of these discussions. So thank you for this opportunity. With the Criminal Justice Research Institute, there are, of course, mandates around studying criminal pretrial data, but also within that, it's authorized to conduct research to study the criminal justice system in a more comprehensive way. And so when I talk about some of these preliminary data trends that we're seeing from the judiciary, it also kind of illustrates some of the future ways in which a more comprehensive approach might help us understand the outcomes and the impacts that we're seeing. So the first data trend or piece of data that I wanted to talk about is around recidivism. Of course, is always an area or an outcome of interest. And recidivism can be measured in many different ways, but for the judiciary and the data that we have, we're focusing on new charges. So when someone had a violation and received new charges, we're using that as our outcome to talk about here. I also just want to mention too, really briefly, that the approach to studying these trends right now, what I focused on was the people released in April, because using that, we'll call it a cohort of people released in April, gives us a little bit more of a follow-up period to study these trends. So when we're studying recidivism, it's a little more helpful and instructive to have a longer follow-up period to see how those trends play out and to capture that information. So for here, we're just going to focus on that group of people. And with this information here, we had 108 people released to the court due to the court order in April, and of those, 63 people had at least one new charge filed. But within that, probably one of the things of most interest here is regarding felony offenses. So anyone who had at least one new charge that was a felony offense, approximately 17% of people released had felony offenses within their new charges. So within that too, we have about 40% of the people that were released had only misdemeanor or petty misdemeanor offenses as a new charge. And about 4% of people released had an infraction as a new charge. And so with this outcome too, just to be clear, as you're well aware, individuals can have more than one charge. Sometimes within new charges, they might have multiple counts. And so this outcome was coded so that if someone is categorized as having a felony, they had at least one new charge as a felony. If someone only did not have any felonies but had misdemeanor or petty misdemeanor charges, then it was coded to that. So it was coded for the most serious offense. And so this, also too, to provide context around this, this is getting at the extent of involvement around people who are released in new charges. The next few slides that I'll talk about soon will instead talk more about the nature of those violations, knowing that people can commit one or more new crimes or have more than one violation or count with their new charges. So this is more about the extent of involvement across every individual that was released. And then too, just to demonstrate where individuals fell across the different circuits, this is probably not too surprising to see that most people who had new charges were in the First Circuit, because more people are involved in that circuit. And so with this slide and the next slide, what I'll talk about is not necessarily the individual level, but instead all the different violations that resulted in new charges. So these two will really get at the nature of the new criminal activity if we're looking at new charge information to describe that. So with this slide in particular, it's looking at across all the different violations across people that were released in April in this cohort, and about 2/3 of the violations across all these individuals and all the instances of new criminal activity, the violations were a misdemeanor or petty misdemeanor offense. About 17% were felony level offenses, 13% infractions, and then 4% violations, and 1% it was unclear in the data. So here we're seeing that, again, about 2/3 of individuals, when they did receive new charges after they were released, most of them were for misdemeanor or petty misdemeanor offenses. And with the next slide, I'll talk about not just the offense level here, but what types of offenses those are. And so, again, looking at all the different violations across the 63 individuals that were released. So this includes the first set of violations, second set of violations if someone had multiple. This demonstrates that the largest category in which these violations fell were for breaking emergency orders or violating emergency orders. And it was very clearly identified in the data that these were the specific charges that individuals had received. So about 37% of those new charges were around those types of violations. The next largest category was traffic-related violations, so 21%. And then the third largest category was around public disorder. And I'm using public disorder as a just sort of general category to talk about things like violating rules around being in the park after hours, obstructing sidewalks with tents, trespassing. So a lot of these community type disorder violations are categorized into that grouping. And I wanted to kind of point out that it's presented next to the emergency order slides because a lot of these violations are kind of similar in nature to the emergency orders, but just more specific to rules around curfews around the park hours and obstructing sidewalks and that sort of thing. Then the other categories, about 10% of the violations were for drug and property crimes. Probably fewer were around drugs and more around property offenses in that category. And then within the 3% there, we see that 3% were for violent crimes, and those were categorized as burglary, robbery, and some assault charges. So those are the types of offenses that were put into that category. And there we see about 3% of all the violations that occurred were in that group. So those are the few data slides and trends that we wanted to highlight and talk about today. These are really seen as preliminary trends. And partly we're calling them preliminary is because there are some limitations to studying this topic right now. So one of the main issues around this is that the follow-up period has not been very long in terms of understanding new crimes and public safety outcomes around recidivism. Typically, we look at a period much longer than 9 months, 10 months. A year or more is much more helpful to really give a sense of the impact in that area. Another thing to point out too is there's a limited picture on how practices have adapted or changed during COVID right now. So everyone, everywhere, including the criminal justice system, has had to change the way they do things due to a lot of restrictions around in-person meetings and activities and groups. And so a lot of that has, of course, happened too across the system. And so to kind of go back to that example of the different types of charges that people were getting around emergency orders and those public disorder types offenses, it's unclear, is it that, for example, are police, enforcing some of these rules more because of concerns around public health and getting kind of people removed from the streets or from congregating? Is it that there's new charges brought in that area because of an interest in that too? Or instead, is it that these issues are more prevalent right now because there's issues around finding housing and services for people in and out of the criminal justice system? And so this is just a reflection of maybe some of the lack of services that exist right now. So trying to understand how all of this has changed is really complicated, and especially when we're using official data like this, when we know that the system has changed, that can influence the data that we're seeing and what we're collecting and what we're measuring here. So there is a need to kind of understand how things have changed and be able to link that to the different data that we're looking at. And that all kind of comes together and relates that if we really want to explore the impacts of public safety and kind of understand how these practices might generalize to longer term lessons learned or other ways to generalize this information into future aspects of the criminal justice system, more rigorous research and data collection would be helpful to just link these decisions across the system and to be able to control for certain things that might be impacting the rates that we're seeing, and to understand how practices and responses have changed during this time. And so because of these limitations, as a researcher, we like to talk about data, but we also like to caveat everything with some of the challenges that we might be facing, or some limitations on how to interpret the information. But I don't want to end it there. It also right now presents an opportunity to study and to understand what the impacts have been on public safety. But in many ways, it also creates an opportunity to really evaluate what's working here. Some of the changes that have been happening are actually really aligned with what the research has been suggesting works to reduce recidivism. And so I'll go through a couple of examples of things at the Research Institute that we've been thinking about and kind of talking about that kind of align with the questions raised today and with the data that we're looking at. So one is that with again, we don't have a full sense of how things have changed and exactly what's changed. And so being able to document some of these changes and understand how supervision has adjusted and how courts have adjusted, how policing has changed their practices, having that information is helpful in terms of context. So any data that is studied in the future on this has that context for interpretation. But it also, there's probably a lot of really innovative approaches going on right now, and many of them probably in line with opportunities to create more efficient practices and to develop more cost-effective ways to do things, because there's a pressure to do so and a need to do so right now. So there's an opportunity to document that and evaluate that and understand, and maybe find some potential new things that have been happening that could be used elsewhere or used more often or be more sustainable for long term. Another area would be around, oops, sorry about that. I just realized there's animation on that last slide that I thought I got rid of. So with this slide, one of the kind of specific policy changes that's really occurred nationally on this issue is around using more remote and virtual options to for some people to supervise them. And there's research suggesting that you can reduce supervision for people who are low risk to reoffend and still have similar public safety outcomes, so without jeopardizing community safety. And right now, more remote options are probably being used, but some of this is in line with the direction of a lot of research suggesting that, especially for people who are low risk to reoffend, so someone who doesn't have a lot of risk factors, could maybe do just as well having a more remote or virtual option for reporting. And when you think about someone who's low risk, most likely they have a job and are, with their families and involved maybe in their community. And so if we're able to remove some of the barriers in reporting, which might require more frequent visits and taking the bus downtown and going from appointment to appointment, kind of limiting these types of things allows them to stay in the community and keep doing things well that are going well for them, which in turn helps keep them out of the criminal justice system. So that's just a more maybe specific example of how some of these changes around remote or more flexible options might be something long-term that could be effective depending on the outcomes that you see here, and also to create more efficient workloads and processes within the agency, and maybe give officers more time to spend with the people who have more needs or to deal with more crises. On the other hand, there's research showing that drug courts, for example, are best for high-risk, high-need people. They have a lot of services and issues that they need and to deal with. And so in many circumstances, you know, their remote type options might not be the right fit for them, or at least not in the beginning when they're first starting out. But there may be ways to use technology to reduce some of the barriers that they face. If someone is involved in a really intensive program or a drug court, you know, they might have a lot of needs and need a lot of treatment and supervision and services to address that. But it also can be kind of burdensome to either take the bus from work to appointments, to, you know, go to different services, to meet all their conditions and do drug testing. So there may be opportunities to integrate some of these practices in a way to support what they're doing and help them as well. So I think those are kind of two specific examples that really stick out to me that demonstrate how there have been changes in supervision and the way things are done, but they're also in the direction of what research would suggest would reduce recidivism and be effective, and there's opportunities to study them here and understand how they work here specifically. And then another another kind of area to evaluate too, or to think about is, of course, right now, incarceration is being used differently and in different ways and less because of other concerns that we're facing. And this might create an opportunity to understand how incarceration is used here. You know, so understanding, for example, if less people are detained through trial, what kind of outcomes do we see? Also, there's some research talking about the use of jail as a sanction, and in the drug court literature specifically, there's evidence suggesting that after 3, 4, 5 days, you start to lose effectiveness, and in fact, you might increase recidivism for people who are in jail for too long as a sanction. And that example is, of course, specific to someone who gets a jail sanction for not following a program rule, not talking more broadly about a jail sentence or a prison sentence. But the idea is that if someone is in the community and involved in a lot of programs and gets that kind of sanction, if they're there too long, they might lose their job, they might lose some of the other progress they made, or might be out of programming, or it creates a lot of discontinuity. And so that's just one specific example of understanding incarceration and how it's used, and ways to study and evaluate that. Again, if it's being used less now, there's some evidence to suggest that there's ways to understand how that plays out, and without jeopardizing public safety as well. And then finally, just another area that is important to understand in this context as well, just going back to, again, the different types of offenses that people received new charges for. A lot of those violations were for emergency order, or a lot of those kind of public disorder type offenses. And so it may be that there's a real need in those areas now, and it's being specifically, or maybe more noticeable, because people are being released into the communities during really challenging times, or it might just reflect a need to evaluate and understand the reentry process to improve and support people as they reenter the community. And so, you know, this question and some of those other questions are really just to demonstrate, one, that the issue of how did public, you know, what happened in terms of public safety, how did these changes impact the community, are complex, and it's, you know, it is difficult to say what the impact or outcome was beyond those trends, but it also highlights some opportunities to understand some new ways of doing things, some new innovations, some new practices, to see how they impact the community long term, and many of which might be more cost effective or create more efficient processes for agencies, but also for people on supervision. So I will I'll stop there. That's all I have for right now. And I didn't know, Judge Viola, Mr. Sakai, if either one of you wanted to add anything at this point.
I think we're ready for questions. Covered a lot. Thank you.
Thank you, Director Harbinson. That was very fascinating. I think speaking for myself and many of the committee members were interested in recidivism and improving the reentry process. You may be new to the job, but you're wise beyond your years. When you have a captive audience of legislators, come in hard with the recommendations and make the most of that time. Members, if you have any questions for PSD or the judiciary, go ahead and ask them. Go ahead and just mention something in the chat that you have a question. I'll call on you. And just as other folks, as a reminder, because this is closed captioned, try not to speak over each other. Otherwise, it makes it difficult. Okay, members, any questions? Well, I will start first. Oh, I'm sorry, Vice Chair Ganadin. Go ahead and unmute yourself and why don't you ask your question, then we'll have Rep. Kobayashi following. You're on deck, Rep. Kobayashi.
All right. Director Sakai, thank you so much for coming into the department during this tough time. We know that you inherit a lot of issues, and we really appreciate your leadership moving forward. Something that you mentioned, there were some individuals that were kept in custody throughout 2020 because either the department or the court could not verify their residence. Is that, I was wondering if that is required by law, or if that is an issue that an individual could return to court for based on a motion by their public defender or their private attorney. Of course, we're interested in the big question here that Dr. Harbinson was alluding to, and obviously needs more opportunity to work on, as to how effective were releases throughout coronavirus. I mean, like, as in, and what were the barriers to releasing individuals, and whether legal or through the state. So I just wanted to follow up on that first, the verification of a residence thing, if you could speak to that. Thank you.
I think you're talking about the 209 that were still confined. This is through the Hawaii Paroling Authority. And what happens is the person will come up for a parole hearing. If parole is granted, if the person has done what he needs to do and behavior is appropriate, parole board will generally grant parole contingent, and the release would be contingent upon verification of a residence, because a lot of these people lack the residence when they exit the facility. The parole board will not parole somebody that doesn't have an appropriate residence. So what we're missing right now is housing, appropriate housing for people coming out of prison. So this 209 is at the discretion. It's a discretionary release from the parole board, but this is not a judiciary thing, I think, at this point. And we also have Chairman Fred Hune on board too, so I don't know if he wants to add anything on to what I said.
Yeah, is Fred on the call?
Yeah, he's on the call.
Okay. Maybe he could expand upon that, either in this hearing or in the future.
No, I'm here. I just got myself off mute. So for those that we have paroled on what we call a chair to set, meaning finding appropriate programs, whether it be substance abuse, mental health, dual diagnose, or to their homes, because sometimes homes cannot be an appropriate placement where there's been domestic violence and or active substance abuse. So the chair to set affords an opportunity for us to grant parole so long as we can verify the residence program and or the program accepts them, and under COVID conditions, a lot of times they want to have a negative result from testing or have been quarantined adequately and show no symptoms of COVID. So the chair to set is one tool that the parole board uses if we can't do direct parole. That's a given date and it's the residence and or program has already been verified and accepting of the individual, which is different from the jail type releases under the Supreme Court order.
Suppose what I'm concerned about is individuals that would be granted release, but for the residence requirement. Of course, it's not illegal to not have a residence here in the state or the United States, so that's a concern. I suppose I'm going to follow up with that a bit after this meeting. Thank you so much.
Okay.
Representative Kobayashi.
Hello. At the intro, Chair Ono mentioned that PD, Public Defender, said that early releases did not compromise public safety. So I assume that the data, at least related to April releases, supports Public Defender's statement or doesn't support. I mean,
Dr.
are you supporting the Public Defender's statements with your data?
Hi. Oh, sorry. Was someone else about to say something? Okay. Yeah. So, in terms of going back to the data, the information that the judiciary, that we looked at was new charges, and I always have to couch it with some caveats and limitations. With that information, new charges, it doesn't reflect necessarily arrests or the actual behaviors out there, but in terms of looking at the new charges, the very small percentage were for related to felony offenses. Most were around the emergency violation orders and kind of those more public level disorder type offenses. So in regards to looking to that data.
Is 17% felony charges high in your estimation or low?
Oh boy.
If you can't answer that, then I'm not sure that you're very useful.
So another piece of information that I think might be helpful in that context is, compared to recidivism rates more generally, that is a low recidivism rate, relatively speaking. At this point in time, we also see trends too in just lower crime in general. So in terms of putting that number into context of just crime trends more generally, for example, there's been an evaluation a preliminary evaluation of looking at releases in about 29 different cities across the country. And in general, there's, despite the releases, there is either similar crime rates or decline in crime rates. So within that context, we see we don't see increase in crime rates at the very least. And then looking at that new charge information, that does seem relatively low. But to, kind of get more at your answer in terms of what does this mean for public safety? What was that impact? I think other data would be more instructive, just because new charges are so system-based.
I think that this is cherry picking upon cherry pick. First of all, the April releases were releases of, I would assume, relatively low offenders to begin with. Secondly, you have only 10 months of data. And given that, I'm not sure whether 17% felony is high or low. If a comparable set of prisoners were released and followed in Hawaii, would you see or expect 17% felony in 10 months?
So, sorry, just to clarify your question, would I expect to see 17% under kind of typical circumstances?
Similar low risk releases, would you expect 17%? I assume that these April releases were relatively low risk offenders to begin with.
Yes. Yeah, and yeah, so if you want to put in that context, that is a low rate. And I don't know if Judge Viola or someone else wants to speak more to the orders in terms of who is considered and for the release. They might be able to speak more specifically to that. But if we're speaking about recidivism in relative terms, that is when, especially looking at the specific types of charges that people are receiving based on this data. They're less serious charges, and it is a low rate for the few serious charges that were included in there.
Chair Ono and Representative Kovish, if I may respond also. I appreciate the question, Representative Kovish, because that is really the question everybody's looking at. I just did want to just kind of reemphasize a couple things that Dr. Harbin said before. It really is true that most of this information is preliminary. It's going to have to play out over time. I am hesitant, honestly, to say right now it's high, low, middle. I think in some ways that's for, depending on your perspective, any felony offense is a serious offense, right? And it would be nice if it were zero. It wasn't zero. But I think there are some other factors, not to hedge on the question, but there are a lot of factors, there's a lot of information we don't have quite yet. I mean, for instance, I think we need to take into account that there are fewer criminal charges being filed, I think voluntarily by the prosecutor's office, I think for many good reasons. Grand juries were not able to be impaneled for a period of time. The 108 inmates that we released, they were pursuant to the court orders that were entered, the first round of court orders that were entered in April. There were a number of other defendants who were released pursuant to other court orders, other motions. Naturally, they made bail. There are a variety of reasons. Again, I don't want to say the information that we have right now, we can't draw any conclusions, but I would just caution to draw conclusions about whether it was high, low, medium. The other part of it, I think that what Dr. Harbinson was trying to address is the circumstances that a number of the inmates were released to were somewhat unique. It was a really challenging time for everybody, right? And the inmates included, because many of them were released without a verified residence. That was not required by the court orders, but that was permitted the courts to require that. The inmates who were subject to release in that first round, they included they included several categories of defendants who were eligible to be released. That was included pretrial misdemeanants and petty misdemeanants who are waiting for trial, misdemeanants and petty misdemeanants who had been serving a sentence after their conviction. It also covered individuals who were on felony probation, but were serving a sentence as a condition of their probation. I think it was less than 18 months. And then also felony individuals charged with felonies who were waiting trial. They were subject to release, they weren't released. But the order that we were, that Dr. Harbinson was talking about in terms of the 108 numbers, though that order did exclude certain categories of offenses, which, for example, individuals who were charged or convicted of domestic violence related offenses, serious felonies, sex assault offenses, robberies, burglaries. So, I mean, I think it is fair to say that, there was a lot of thought given to not even, considering the release of certain categories of defendants. But I think there were a number of individuals who were charged or convicted of felonies who were released. So anyway, just kind of I wanted to share that context.
I think you've just verified what I had thought earlier, that this was cherry picking upon cherry picking. That is, the release was, to begin with low risk offenders.
Mhm.
Secondly, within those low risk offenders, you cherry pick further low risk offenders, and others were not even considered for release. So it looks like, at least in this first month of April, you really had low risk, very low risk offenders being released. And then you're doing your research on this, shall we say, cherry pick group.
Well, I don't know if I would say cherry pick. I can see why you might say that, but what I would say is what the release orders took into account at the very outset was not to even contemplate that people who were at high risk of committing serious crimes in the community wouldn't even be subject to release. So we weren't really cherry picking, in terms of the data. And I should also say that, right now we have that data. That's why we presented that. We have those numbers. We have that information on the follow-ups. We have information on who got charged with new offenses for that group. And that's what we were, given the time frame, we were able to provide. And that was because the legislature had asked us to provide that information. I forget what the bill was last year. So we have been reporting that. So we have that data for sure. That is not to say that there were a number of other individuals who were released during that time period. And what I would just say now, Representative Kobayashi, is we just don't have that information yet. Not that we're ignoring it, we're intentionally cherry picking it. We just don't have it quite yet. So there was certainly, I would venture to say, that there were certainly a number of those other individuals who were released during this time frame, not pursuant to that specific Supreme Court order, but who were released during this time period, who also incurred new charges. I guarantee it. I don't know what those numbers are right now, but our intent certainly wasn't to present this in a way that makes it look any way other than what the numbers show. And,
Okay.
I appreciate your question very much. Mm-hmm.
Thank you, everyone. Rep. Kobayashi, I get your point that if this was a low risk category, you might expect the recidivism rate to be lower than the general release. Vice Chair Gannon, you have another question, and if any other members do, just raise your hand in the chat. Vice Chair Gannon.
Director Otani, this was a census year. We understand that there might be a lawsuit from a non-governmental organization requesting that the department allow individuals who are incarcerated to vote pursuant to the Hawaii State Constitution. We're wondering how the department, it was also a coronavirus here, we're wondering how the department counted individuals and allowed them to input their residence. So as in, could they put in as a residence the facility or where they originally picked up from, if they are houseless or their current residents. Of course, this is important for voting rights and for this year's political redistricting.
You want to give a response? Yes. Hello, this is Tommy Johnson, the Deputy Director of Corrections. The inmates who were eligible to vote were allowed to vote. We got the absentee ballot sent to the facilities, and the facilities help the inmates complete them, and they were mailed out from the facilities. So for those that were eligible and wanted to vote, they were able to vote. There were a number of inmates that didn't want to vote, and we couldn't force them to vote. Yeah. The residence was the jail, was the prison, because that's what their residence was at the time. I could go back and try to get some more specific information and get that to the chair.
Sure, thank you. Rep. Gannon, another question, and let's redirect it back to the inmate release.
Right on. So regarding the facility, the core civic facility at Saguaro, I'm wondering the kind of thought process that happened by the Department of Public Safety, especially as you folks transitioned leadership. You mentioned earlier that a flight was canceled from Saguaro to here. I'm concerned that the department, maybe through no fault of its own, held individuals further than their sentencing date. I'm wondering if you could go into that.
The flight was canceled from Halava to Saguaro. We brought the inmates back, but we didn't send any inmates to Saguaro.
So you mentioned earlier you brought back 79 on December 9th?
December 8th, I believe.
December 8th.
Yeah, December 9th. Correct.
Okay. This is going to be one of the many years that we discuss the state's contracting with private prisons. This is a national issue. So I'm wondering if the 79 reduced bodies would change the contracting with the private prison, as in, would it reduce the state's set contract? I believe it's at $47 million per year with Core Civic. Those were from numbers that I saw just a few years ago.
We pay per bed. We pay per bed occupied.
So is it reasonable to say that that as we bring individuals back from Saguaro, we save money?
Right, but the problem was that we couldn't send the ones that we needed to send up to Saguaro. So our capacity up in Halava right now is close to 100% at our operational capacity. And given the pandemic, it's not a very good situation up there, having that many people crowded into that facility. So the plan was to send 150 out, but we kept the 150 plus the 79 that came in, which increased the population at Halava at that time.
Okay.
Thank you.
You may continue, Vice Chair.
Oh, thank you so much. Director Otani, we're so sorry to have you keep coming back to the legislature. We understand that you had a presentation before the Senate just a few days ago. You mentioned before the Senate the department's new budget. There are some concerns that there might be a cut to reentry programs. So I was hoping that you could follow up on that. The concern is recidivism, so we're going to keep coming back to this. And there was also a big discussion just prior to the pandemic about the continuation of the department's contract with the Fernhurst YWCA facility, and a lot of folks took issue with the potential cutting of that program. So I was hoping you could discuss the department's conceptualization of reentry programs moving forward.
Well, I think the contract for Fernhurst is in, we have money appropriated for that program, so that Fernhurst will continue. As far as the budget, you know, we looked for where we could reduce funding to meet the budget cuts that we were required to meet, and some of it had to come out of programs and operating budgets. But as far as Fernhurst, if you're focusing on Fernhurst, I believe, you know, we have a contract in place right now, and it's fully funded.
Is there going to be a cut in reentry programs in the new budget?
It's premature for us to say because we don't have the finalized budget yet. We do know we provided scenarios to the governor regarding 10, 15, 20% cuts in the budget. We did provide information on programs. Some of our funding will be taken away from some of our correctional officer positions and other positions, but we're unsure yet for the next budget beginning 1 July what it's going to look like.
Thank you. Have people been able to continue with their program so that they can meet their parole? I'm sure it varies per facility.
It's very from facility based on whether the facility is locked down. I believe some of the other facilities are opening up. Arizona has opened up their substance abuse programming. Guayaba opened too. Yeah, Guayaba has opened up. So I think right now it's just because of the current status at Halava, programming is not being available at this time.
So are people, because they cannot meet their programming needs, finding it difficult to meet the requirements of release under probation?
Well, the recommendation for parole, and maybe Chairman Hyun can explain a little bit better, but they've been looking for programs on the outside if the inmate has not been able to meet the program requirements on the inside. But I'm pretty sure Chairman Hyun can explain it a little bit better than I can.
So when there are some of the programs that were shut down, like low-level substance abuse or cognitive, we've allowed inmates and their attorneys, if they can find and receive acceptance into an outside program, and we do have a residence for them, or an outside program has the cognitive or the low-level substance abuse, then we will grant parole to that, despite the freezing of programs in the facilities. So we try and be creative and look at other options so we can get them out and reduce the population. But you should also realize, and we've expressed this to community advocates before, that a lot of the programs may have a long wait list and require money up front. And a lot of times people don't have the money to put up. So say, for example, Poilani, which is a dual diagnosed type program, had at one time 100 plus on the wait list. So it's very difficult for us to get inmates out and paroled to that type of Poilani program. Another program, a Clean and Sober, had 160 on the wait list with $450 deposit upfront and $450 per month for their stay if they weren't contracted with public safety. But, we do look for creative type of programming if they cannot be accomplished within the facilities. Can I also touch on another point just to clarify Representative Kobayashi's cherry picking comment? Under the Supreme Court order, because I was involved in that from the beginning, the discussions had been between the public defender who had raised filed the complaint and made the motion with the Supreme Court. Ultimately, it came down to a bunch of teleconferences and the fact that it was agreed to that serious offenders, like Judge Viola indicated, for high type offenses against persons or sexual offenses, they would be excluded from the mix. However, because a lot of these were sentenced felon probationers or pretrials, the argument had to go before the respective judge, as indicated by the justices, and arguments made between prosecutor because they needed their time, as well as the defense attorney. From there, based on a court's decision, people were released. So it wasn't really a bunch of it wasn't really cherry picking, but it was based on legal arguments that went before the court. And that was the population that was released. Some with residents and a lot without residences.
Thank you. Okay, Vice Chair Gannon, one last question.
Right.
At least for the time being.
Got it. This is to the department. and possibly to former Director Hume, to comply with the Oversight Committee's suggestion to reduce crowding, especially here on Oahu. Is the department still looking to utilize bed space at the Federal Detention Center?
Yes, we are. We started conversations with the Federal Detention Center, and Tommy's been real instrumental in that. And we made referrals for possible cases that they could take and transfer the inmates over there.
How many individuals?
Right now, the MOU between the Department of Public Safety and the FTC only calls for 100 offenders maximum. Right now, there are 28. I talked to Warden Durr of the FTC last week. She agreed to look at cases for possible transfer. So we are looking at moving inmates from the Halawa Correctional Facility that are post-positive and from the Maui Community Correctional Center that are also post-positive for COVID to the FTC to fill up those remaining bed spaces there. The problem with that, so we're clear, is that the FTC is a detention facility. So inmates that have serious medical conditions are not allowed to go there. They're all housed on one floor, so that there are separatee issues for gang-related issues or co-defendants. They cannot be housed there as well.
Thanks to the chair for the time.
Thank you, everyone. The chair has a couple questions. I'm going to start with the judiciary. We'll start with Director Harbinson, and if you want to phone a friend, feel free to go ahead. Dr. Harbinson, you talked a lot about the April folks who appeared in your reports, but there is information on folks who have been charged and who were charged in months after April. Can you tell me, were there folks on that list who were charged multiple times on multiple dates?
Sure. So yeah, specifically following the individuals released in April, there were people who had multiple charges, and some of those charges did include, from what I can tell, multiple counts, and sometimes, if I remember correctly, varying dates. There's always one I could go back into the data to look more specifically. Does that answer your question, or was there something more specific regarding that would be helpful for me to look into?
In the months subsequent to April, in the reports that have been reported by the judiciary, there are a number of individuals who have been charged multiple times on multiple dates. In fact, I found one person who was charged 15 different dates during the months since then, all the way through our current reports through January. One of the criticisms that the program received when this first started was that for folks who were released without addresses, we did so knowingly that we were under a stay-at-home order. I know one of the suggestions is that officers, one of the suggestions you made is that officers could use more of their time on high needs cases, perhaps addressing some of those felonies. And I wonder if some of the releases that happened took away time because either one, we did so knowing that they didn't have a place to go, or two, some of the folks who we released, in fact, turned out to take up time from law enforcement on multiple occasions, on multiple days. To Representative Kobayashi's question, I guess I'd just like to add some color to some of the stats that you presented. While most of these charges or allegations were nonviolent, my question to you, Dr. Harbinson, are allegations of credit card theft, indecent exposure, urinating and defecating in public, driving with a suspended license, identity theft, in your mind, do those compromise public safety?
So I'll go back to, I think, one of the challenges with using the new charge information. At face value, in terms of public safety, It will vary person to person what we would call as jeopardizing public safety in terms of identity theft or some of these. I did broadly categorize some things into public disorder, but that was just kind of an exercise here to sort of condense and summarize information. But there is some subjectivity into what offenses would be considered more serious. In many cases, even the offense levels that we have might not reflect seriousness for some, depending on your perspective. And so related to that, and then just related to when you're looking at new charges, there's one of the reasons when trying to understand public safety, it's really important to look at more than just one measure, is because all of them are limited in terms of what they explain, and they are official data, which is going to reflect to a large extent the nature of the practices and the way things are done. So for instance, having arrest information might give us more insight into what the actual behaviors were looking at those reports, because on face value, something that might have been, a violation of being after a park after hours may seem minor in some circumstances, but in other may actually be more concerning. And what people are charged on might not necessarily reflect the nature or extent of the public safety issue at hand. And so I realize people want answers. What does public safety mean? How do we impact public safety? But from a research perspective, it's really challenging to make kind of a statement either way about that, because not just the time period issues and just the way things have changed, but because new charges are just one picture of that and reflect what's officially being filed and might not reflect what actually happened and the nature of what happened and how often it happened. And so, yes, what you're, to give your example of someone, there were a few people, or more than a few people, who had at least a few charges, and within those charges, a few counts. And there were some people who did have multiple charges, and so it's difficult to say, was it that they couldn't find a house, and that's why they kept getting violations around being in the park, or was it related to some other behaviors that officers felt it was necessary to intervene in some way, because at least they had to do something to respond because of other concerns or other public safety issues. So I don't know if I didn't really give you a direct answer for that, and just I think I keep coming back to, this trend is preliminary. It gives kind of a benchmark for what happened with people released in April. It could be helpful to compare additional people that were released and to compare relative to other time periods, but at the end of the day, if the ultimate question is how is public safety impacted, there's a lot kind of linking of data and a lot more methodological considerations to think about and put together to get us that answer. Just because, as you mentioned, it's a perfect example of why looking at this information specifically at this snapshot in time is limited in understanding that picture.
I'll turn my attention to Judge Viola under the same pretense. Admittedly, yes, these are allegations. These are charges against these folks. And also, as Dr. Harbin's good work is done, that a plurality of the folks of the new charges are non-violent, perhaps trespassing, in a park when it's closed. Regardless, there are some of those activities I described in further reports that were detailed after the month of April. There are other charges that jumped out at me. Some folks, like you mentioned, there's a sexual assault in there. There's a charge of ownership of a firearm as a felon, promoting detrimental drug, criminal trespass, robbery, burglary, assault. Judge Viola, remember this program was, it was a special program, and had this been in 2019, I don't know if all the folks who are charged with the aforementioned activities would have been out on the streets. Do you want to re-respond and understand or provide more context as we as lawmakers try to understand, was public safety compromised under the inmate release program during this COVID-19 pandemic?
Okay, if I can kind of reiterate what I said before.
Oh, you just went on mute, Judge Viola.
That wasn't intentional, by the way.
Okay.
I did want to just re-emphasize what I said before. I am a little bit, just on behalf of the judiciary, hesitant to draw the conclusions right now or to categorize it some way. I mean, clearly, some of the offenses that occurred, there's no debate that they compromised public safety. And there were, even though many, I think most of those cases have not been fully resolved, the individuals who are the victims in those cases suffer the consequences of those individuals being released. So no debate there, Chair Ono. I think it's the bigger picture is a little bit hard to draw a conclusion, say it was successful, not successful. I think it maybe the question might be framed this way. This was a quite unique and difficult situation because not just there were considerations about protecting the health and safety of not just the inmates, but the individuals who worked at the correctional centers and the prisons, their families. It was a tough situation. I can say that. I can say for myself, every single case that I reviewed took up a lot of time. It was taken very seriously. The impact on public safety was paramount in every single case. We had some limited information, and these decisions were made in a compressed time frame. That's just by way of background. That's what we get paid to do. That's what we needed to do that. So we were not perfect. That would say it would have been great if no one committed a crime. That's not the nature of the population that we generally deal with. So, anyway, that's a little bit of a general response. I would also like to just kind of point out a point that you made, Chair Ono. The individuals who were subject to the release, they were put in jail. Generally, there was a court order keeping them in jail. They were put there in the first place, right? There was some, generally, for the most part, some judicial determination that they needed to be incarcerated. I think it is fair to say that many of them would not have been released under these circumstances, or at least in that short time frame. It was an early release program. Many of them, I would say most of them who were subject to the release would have been released in the future because of the category of the individuals who are subject to the release. Pending trial, some of them would have, especially for the misdemeanors, petty misdemeanors, I think many of them were incarcerated for longer than they would have their ultimate sentences that they would have received. Some of the felony probationers would have completed their term of incarceration as a condition of their probation. Other of the felony pretrial defendants would have been released because they would have gone to trial, got acquitted, and maybe not been sentenced to jail. So, it was a little bit of a unique situation right now. It's hard to say. It really, truly is. I'm not hedging. I'm not trying to avoid the question, but it's hard to say. I mean, the numbers, I guess what I would say, Toronto, is the numbers are the numbers right now. I certainly have my opinion on some of the individual cases. It's always distressing when someone you release commits another offense. But it was somewhat of a unique situation. I'm sorry, I don't know if that responds to your question. I don't want to avoid it, but it was some hard decisions had to be made.
Thank you for sharing your thoughts, Judge Viola. Perhaps to overuse the most overused term in the past year, it was unprecedented time.
It was, yeah.
There was no playbook. So we appreciate you doing what you had to do, knowing that we were perhaps driving blind and not sure what we could have expected. And that's why some of these conversations and your cooperation is so helpful. I have some questions to PSD briefly in the time remaining we have. And if any other members have any questions, again, just say something in the chat. Director Otani, thank you for being here again. I just wanted to ask you very briefly if you want to touch upon it. Do you think public safety was compromised by the release of these inmates in the most general terms that you can define for yourself?
Well, I think as was stated earlier, anytime somebody gets arrested and you have a victim out there, if you or I were the victim, of course it's public safety, whether it's someone cracking your windshield or someone defecating in your lawn or whatever it is, it's the individual. But I think, as the judge has explained, it was a calculated risk on a very risky population because they were already in jail. You know, if they weren't there, they would have been diverted earlier from the courts. But given their circumstances, you know, they were ordered to be remanded to jail. So, you know, in a sense, even if you use the term cherry picking, you know, you weren't getting grade A cherries at that point. You know, you were getting people that actually belonged in jail. So it was a very risky population. And I think that's why the arrest rate was so high on my personal view.
Thank you. You mentioned, I just want to confirm, you mentioned that the inmate releases ceased as of November 20th, I believe. Did the inmate release program deter COVID-19 spread in the prisons and jail facilities?
Yeah, you know, we released them, but people kept coming in. You know, it's not like we closed the door and no one came in. You know, with the help of the courts, you know, there were people that were released, but we still had admissions coming in. And the facilities are, you know, are at capacity, well, maybe not at operational capacity, but at design, more than design capacity. So there is no way that we could probably, you know, do the social isolation there. So, you know, if the virus does come into a facility, you know, as we've seen with, you know, right now, 3 of our facilities, it'll just spread very fast. So it's hard to say, you know, whether or not it did. You know, I think it helped a little bit because it created, you know, some room for managing the inmates a little bit better. But, you know, they're still, you know, 2 in a cell, you know, and they still mingle among others. So once the virus comes into the facility, you know, it'll just catch on. And you know, we've seen that in the hundreds of 3 facilities here in Hawaii.
Okay. Members, are there any final questions? We have about 5 more minutes of these folks' time, so their generous time. If you have something, just again, mention it in the chat. Okay, looks like everyone's off the hook. Members and presenters, thank you for, again, your cooperation and spending some time with us to look back on some of the actions that happened over the last 9 months. I think I'm excited to hear more from Ms. Harbinson, Dr. Harbinson, and your work as the months and more data is available. Everyone, please stay in touch. Please stay safe. Happy New Year. Take care. We're adjourned, folks.